All right, let's get into the back and forth about the state-level cases that are challenging Illinois' gun and magazine ban. Good morning. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And we've been tracking this all day, every day since January 10th when Governor J.B. Pritzker enacted the ban on more than 170 different semi-automatic weapons and shotguns and pistols and rifles and magazines, of more than 10 for rifles and more than 15 for handguns. Also a gun registration that you're going to have to tell state police what kinds of firearms you have on this list of banned weapons. There's penalties, criminal penalties if you don't comply with this. That window opening up October 1st through January 1st for people to register with state police. So that time is approaching. But in the meantime, since January 10th, a stack of lawsuits against the gun ban and the magazine ban and the registration. You've got 4 cases that were filed in state-level court, and now 4 cases that one was filed in state-level court, transferred to federal court, but there are 4 altogether in the Southern District of Illinois that has a status hearing actually set for Friday. So we'll do what we can to bring you the latest out of that. Of course, you can follow along with me live in real time, either from 6 to 9 here on WMAY, but in the afternoon, track me with Bishop on Air, Twitter, Facebook, and you'll be able to kind of get an idea of where I'm at, what I'm doing, what I'm working on. But with the ongoing litigation for the state-level cases, there's 4 of them, and we have temporary restraining orders in place on all 4 of those cases with thousands of plaintiffs that are safe from having the gun ban enforced on them, including gun stores, where individuals in gun stores are able to exchange goods for services and goods for money. So yeah, it's ongoing. These 4 cases, they have temporary restraining orders. Attorney Thomas DeVore filed to combine all 4 of these cases, 2 in Effingham, 1 in White, 1 in Macon County. And he's been openly critical of the attorney in the Macon County case and his direction that he's taking, and actually said that he feels that they're going to get to the Supreme Court too prematurely and have a ruling out of the Illinois Supreme Court that would prejudice DeVore's attempts to try to get more information about how this measure passed and the debates and the negotiations that happened among the supporters of this legislation and the governor's office in crafting and passing this law that they say is unconstitutional. So the separation of these cases, it's going kind of their independent direction. However, in a circuit that has already upheld a temporary restraining order when it comes to questions about the law violating equal protections, because the law carves out certain law enforcement and even prison wardens. And this is something that DeVore is trying to get after, is how that decision came about so he can build that evidence. So he's worried that the Macon County case is advancing too quickly to possibly end up prejudicing DeVore and his attempts to get this information. I reached out to Jerry Stocks. He is the attorney for the Macon County case, and got his reaction to some of the back and forth here when it comes to the issue of consolidation, when it comes to the questions that DeVore is bringing up. So here's Jerry Stocks reacting a bit to whether or not he's, number one, going to withdraw his case, but most of all, what are the important differences?
Certainly. Our objectives in the Macon County case is to reach final judgment expeditiously, declaring the statutory enactment invalid. A judgment, a final judgment that it's invalid constitutionally informs the basis for the state's appeal direct to the Illinois Supreme Court. We will win the case in Macon County. The judgment will be in favor of the plaintiffs. It is not the judgment on each of the or the rulings on each of the bases supporting the judgment are not what one appeals. They appeal the favorable judgment. And I'll be able to defend our favorable ruling in the trial court on any grounds present in the record as we move forward. and I don't know what you have had on tape, but we disagree on the materiality of the discovery sought by Mr. DeVore for purposes of the challenge we are advancing. And we really have reached an opinion that it is not necessary. I really am reticent to engage a back and forth on any particularized points because a lawyer should not litigate his cases, discuss his strategies and the reasons therefore in a public forum. That's information that resides with the client and the attorney. So I could say a lot of things, would love to say much in response to what I'm told or understand Mr. DeVore may be dispensing in his public communications.
And again, what DeVore has been talking about is building that case, subpoenaing the Speaker of the House, the Senate President, the governor's office, and getting the documentation that either shows or doesn't show that, the issue of training for law enforcement or wardens was the rationale for allowing them to be carved out and given the Second Amendment rights of securing semi-automatic weapons of a certain sort and certain types of capacity magazines. It's the training that they get that makes them eligible for that. Well, DeVore's trying to show how that came about, and he's also getting information about prison wardens. We'll hear a little bit more about that, but Stocks responds to DeVore publicly saying that Stocks needs to withdraw his case, and Stocks also talking about how they have now officially opposed consolidation of these four cases. That's a filing that Tom DeVore made on Valentine's Day with the Illinois Supreme Court.
Correct. We already have opposed the consolidation, and the Supreme Court has the matter before it, and we'll wait to see how it concludes the issue. We are withdrawing nothing, and personally, I disagree with many of the procedural assumptions, evidentiary assumptions that inform, to the extent we can actually figure out what legally is informing Mr. DeVore's comments. We're just not in accord. So we view the world differently. We evaluate the law, evidence, and process differently. And he should be free to pursue it as he sees it without interference on his part in our pursuits as we see it.
So again, Jerry Stocks, the attorney for State Representative Dan Calkins in the Macon County case, responding to Attorney Thomas DeVore, asking for the cases to be consolidated, but also publicly saying that Stocks needs to withdraw his case from the Macon County case, worried that if it gets to the Supreme Court, a negative outcome could prejudice the outcome in DeVore's cases. But just to confirm that Stocks did join with the Illinois Attorney General in opposing consolidation, according to the official filing in these cases.
We joined the AG. We were both required to file yesterday and filed yesterday our
that would have been Tuesday
position on his motion to consolidate. We both opposed it. We opposed it on the basis that we are pursuing matters differently procedurally, and that the case filed in Macon County does not have identity of issues. There are a few material differences between Mr. DeVore's position, at least at the TRO stage, in accuracy firearms, that we had the benefit of seeing that we have changed and addressed a little differently in our case. We also have a special legislation attack that is not present in accuracy firearms. We have more substantial allegations of class similarity, which was a critique point in the accuracy firearms dissent. So we are not on all fours. Now, we could be now because Mr. DeVore could do many things, amending pleadings, further fleshing out issues in his respective cases, and may have done so. I just don't know. But we are, some of the issues that were illustrated in the dissent at Accuracy Firearms are not issues that we suffer in our Macon County case.
So coming back, we will hear from attorney Thomas DeVore, who's looking to consolidate these cases, looking to get as much evidence as he can to prepare for presenting in front of the Illinois Supreme Court, and his response to Jerry Stocks saying that no, he's not going to withdraw. No, he doesn't like consolidation, and we'll see where this goes. Giving you both sides of even the gun rights advocates cases, right? So I always strive to kind of give you both sides of what's going on, all sides of what's going on, because there's not only just two. But interesting to hear some of the back and forth in these two cases that could have some significant implications on the state's gun and magazine ban. So stay tuned. We'll get to that next here on WMAY. I'm Greg Bishop. Follow along. Bishop on Air, Twitter, Facebook, YouTube. Just search it out and we can connect that. All right, big shout out for those listening on YouTube. Albert, happy Thursday. Sorry to see you got so much fog up there. It's kind of wet down here and the temperature's just going to drop. Is it Zhang? Morning. I'll have to look into that. Possible ban on bulletproof vests. Well, there's a lot of stuff that they file at the State House that this is kind of considered one of those times of the year where they throw a bunch of stuff at the wall. There's more than, 6,000 bills or something like that have been filed. So we'll see if we can pour through all of that. Of course, they're going to be in session through mid-May, so we'll be getting a lot more into the bills that they're passing. Josh, you say you usually listen live, but sometimes you miss the show and you listen afterwards. That's awesome. Albert, good morning. Get that coffee in you, and I read 3 newspapers myself in the morning, if not more, just bouncing around all over the place. So yeah, awesome to see you guys kicking wing. Yeah, let's see here. What would the state do if nobody registered their firearms? It's an interesting question. And you've got others chiming in as well. A lot of comments there. I appreciate everybody for chiming in. It's something that fuels my fire knowing people are listening, not just here locally, but even around the country, let alone up and down Illinois. So let's get back into it with the back and forth of attorneys who are in the state level challenges of Illinois' gun ban, battling over the idea of consolidation. Listen, these 4 cases are all challenging the state's gun ban, but there seems to be different legal approaches being taken by the attorneys. We heard from Jerry Stocks, who has the Macon County case with State Representative Dan Calkins last segment, responding to attorney Thomas DeVore, saying that the cases need to be consolidated and Stocks needs to withdraw his advance here because Stocks moved up a hearing date from March 20th to March 3rd. So March 3rd is coming up just around the corner, and if there's a decision in that case, it could go to the Illinois Supreme Court pretty quick. Could that prejudice Tom DeVore's case as he tries to compile evidence to show, in his estimation, that the state improperly says that the bill allows for police to be carved out because of training? He's trying to build that evidence to take that to the Illinois Supreme Court. Eventually, here's my conversation briefly with Tom DeVore from yesterday, reacting to Stocks, who was reacting to DeVore. So the back and forth and back and forth.
When that case was first filed over in Macon County, I had concerns, Greg, because it is a complete rehashing of the legal arguments that we had put together. It's substantively identical down to the footnotes. I don't have a problem with my colleagues bringing these causes of action. And it's not just me. There's other lawyers that think and are going to agree with what I'm saying to you. Do these types of cases that are very high profile with very good lawyers on the other side. These lawyers for the Attorney General's office are some of the best in the state. And so when you file these cases, you can't do it very flippantly without really having done the work yourself and the analysis yourself, because the devil's always in the details. So when you just copy and replace it, you may have not done all of the thought process that you should do. So I was like, okay, maybe not, but that was always an initial concern. Once these cases started to proceed, I could tell very early on that the Macon County case didn't have the desire to do the legwork and put forth the tons and tons and hundreds of hours it takes to thoroughly prepare for what is to come when this case gets to the Illinois Supreme Court. And once I saw that, I started having the concerns because I knew that the governor's lawyers would do everything in their power to do a quick rush job to the Supreme Court because it benefits their arguments. And I don't disrespect them when I say that. I understand it. If I was those lawyers for the governor, for the attorney general, I would be doing the exact same thing because that's how I make the best case for my client. Having known that's the case, I said, no, we're not going to do that. We have to thoroughly do discovery. We have to prepare for every possible scenario that the Supreme Court might throw at us once we get there. We cannot just assume that they will follow the reasoning of the appellate court. It's dangerous to assume that. Could they follow it, Greg? They might. And if they follow that reasoning, probably be okay. But you have to prepare, given that this issue could affect the rights of the citizens for eternity, you have to be prepared for all potential outcomes and all potential arguments the Supreme Court might throw at you. And so if the Supreme Court throws at you, well, the governor's arguing it's only a lower level of scrutiny and it's about training, etc. What do you have to say about that, Mr. Stocks or Mr. Calkins? They have nothing, Greg. They have nothing because they haven't taken an extra 3 or 4 months to gather the discovery that is needed to push back against the issue of training. Let me give you an example. Prison wardens are exempt under this law, and the governor has taken the position in the legislature that's because of their training. The evidence will show that we are gathering that only 13 of all of our up to 46, they say there's only 27 prison wardens, but we have 46 prisons. There's only 13 of those men and women who have any firearms training at all. And of those 13, none of them have any training on these exempt categories of weapons. They're only trained in a 9mm handgun. We are developing that record because it will be imperative once you get to the Supreme Court to have to put that argument in front of the court to show that to the extent you are believing that training is a legitimate basis for exemption, these people aren't even trained and it's complete and utter facade, and you need to not grant them that relief. It is imperative that that argument be made in order to have every corner and every base covered when you get to the Supreme Court, which takes time. And the governor didn't want that. And again, not disrespecting the governor. I understand why he doesn't want that record developed. And so they went to the Macon County team and the Dan Calkins, who, whatever reason, I'm not going to start putting reasons on it. There's people across the state now that are trying to put reasons on why these men are doing what they're doing. I don't have to do that, and I'm not going to do that. But ultimately, whether they don't want to put the work in or not, they're not going to do that. And they're going to try to run to the Supreme Court wholly unprepared, undertaking the chance that the Supreme Court just agrees with the appellate court and says, strict scrutiny, none of these facts matter, and Governor, you lose. If the Supreme Court doesn't do that, that case in Macon County is guaranteed to lose, Greg, guaranteed to lose. And I don't know why anybody would not take the time. Again, we're not talking 3 or 4 years. We're talking 3 or 4 months to gather the information like we're gathering in order to be prepared for the chance that that occurs. I offered to Mr. Stocks. I said, I will do all of the work. I will give you all of the information. And you and your client can go and argue it in front of the Supreme Court. If you want to be first because it gets you some kind of status, if that's your motivation, I don't know that it is, you can have it. And you don't have to pay for it. You don't have to do the work. And they said no. So there is no, in my opinion, Greg, there is no rational reason whatsoever why anyone on one of these cases would run to the Illinois Supreme Court in such a rushed reason without being prepared for every available opportunity that the Supreme Court might throw at you and every issue they might throw at you. This is too important of an issue to be so flippant about it. And that's why I got a problem with it, and that's why people need to understand.
So it's a lot there. Attorney Thomas DeVore sharing his thoughts about the status of whether or not these cases are going to be combined and consolidated, a request he made for his 3 cases to be combined with Stocks' case out of Macon County. Stocks opposing that, joining with the Attorney General's office in opposing that consolidation. Stocks saying that he's looking for a different type of relief than what DeVore is looking for, and that DeVore's process could be protracted, be too long. And he also said that whatever outcome comes out of the state Supreme Court, Stocks said he believes it won't prejudice DeVore's case. Well, DeVore, he pushes back against that idea.
He's wrong, because what the governor wants to do is he wants a ruling out of the Supreme Court on their poorly prepared case that says that equal protection should be applied in a certain way, and they're going to try to come back into our cases and say that that's binding precedent, that we can't even continue our cases any further. That's the whole thing that the governor is trying to accomplish. And again, not disrespecting. Their analysis and their path is what they should be doing, but they just got another lawyer to fall for it. They're going to try to use that case to get rid of our cases, Greg. That's the only reason that they're running to the Supreme Court so fast, is to try to get a quick ruling out of the Supreme Court on a poorly developed case that then would bind our case. And so talking about a facially, none of that even legally makes any sense. So with all due respect to Jerry, it's completely ridiculous. And he's going there completely unprepared with an argument that, again, I want to be clear, Greg, with an argument that might win. But if it doesn't, the other argument that he needs to still be able to win, he's going there completely unprepared and doesn't have that argument developed to where he has another shot out of his barrel. I'll use the analogy to say, okay, we still win even if the court does this. Why you wouldn't do that? You will not find another lawyer in the state of Illinois, objective lawyer, if you ask them what you and I are talking about, that doesn't agree with what I'm talking, because they're calling me from all over the state. Lawyers from the north that are watching this going, Tom, what are they doing? I'm like, I don't know. I don't know. And there is no legal reasoning that justifies rushing to get there unprepared, Greg. There's no legal reason for it whatsoever.
So again, Attorney Thomas DeVore laying out his response to Jerry Stocks filing to not have these cases consolidated with the Illinois Supreme Court, and that decision is still pending. So whether the Illinois Supreme Court does consolidate these cases, which might benefit DeVore in getting more time to build his arguments, but if they don't consolidate the cases, then Jerry Stocks' case out of Macon County could be advancing with a hearing on March 3rd, and then possibly a direct appeal to the Illinois Supreme Court. So we'll see. We'll track what happens here. Meanwhile, in the federal cases, there's 4 different cases. A judge has said there's going to be a status hearing on Friday to talk about possible consolidation and the state's brief schedule for when they have to respond to injunctive relief motions from the plaintiffs in this, all around Illinois' gun and magazine ban. A lot going on here. We'll see if we can get some calls in. I don't know. We're plumb out of time. It's 6:54 on WMAY. I'm Greg Bishop. As some are saying on YouTube, be sure to hit the like button, all right?
It's time to apply at Culver's West on Wabash. We're